All rise. The Court of Appeals, Division 1, is now in session.
Please be seated. Good morning. We are here for oral argument in our case number CV18-009, BESS et al. V. SPENO et al. These proceedings are being recorded, so we'd be grateful if each of you, when you approach the podium, please give us your name and the name of the clients you're representing. As you all know, each side is allotted 20 minutes for argument. An appellant, you may reserve any amount of time to use in your rebuttal, but you are responsible for keeping track of that time. The clock on the podium reflects the total time you have remaining, including any amount that you may have reserved. Please keep in mind that we have read the briefs, we have reviewed the record, we have conferenced this case this morning, and with that, you may begin.
Good morning, Your Honors. Carolyn Goldman with Goldman & Zwillinger, representing the appellants who are plaintiffs, counter-defendants, and third-party defendants. This action arises from the defendant's breach of contract. Groups of the plaintiffs jointly funded 8 commercial loans with the defendant, Mark SPENO, his wife, Rhonda Lalonde, and other entities which they controlled. The parcels of real property which secured these 8 commercial loans included a parcel improved with a medical office building, as well as several large multi-acre parcels of raw land. Some parcels were located in the Phoenix metropolitan area, and other parcels were located in more outlying areas such as Prescott. Because the funding of these loans was such a significant investment, the parties entered into contracts with respect to each of the 8 loans, and the contracts were substantially identical. The parties in the contracts contemplated and provided for the possibility that the borrowers could default in repayment of the loans, and the parties would have to foreclose the deeds of trust and thereby become owners of the 8 properties. The contracts further address what would happen if the parties became owners of the properties and had to preserve and manage the properties, and if the parties decided to sell the properties. In particular, the contracts provided for the hiring of attorneys and real estate brokers. The parties clearly stated that all such matters, and in fact all decisions relating to the subject loans and the properties, would be governed by a simple 51% majority vote of all of the parties. It is undisputed that the defendants, Mark SPENO and the other defendants, refused to abide by the majority vote on various occasions. For example, in 2006 and 2007, at the time of the Great Recession, all of the many plaintiffs, counter-defendants, and third-party defendants you see on the caption of the complaint all agreed that it would be beneficial to the parties to wait until market values returned after the Great Recession, because if the properties had been sold at that time, the parties would have lost a great deal of money. They would not have even been able to recoup their investment.
Can you I know you've got in front of you the 2-page operating agreement, probably memorized it. Can you identify for us the language that specifically covers this situation in your belief that a 51% vote will cover the decision to sell a property?
Your Honor, there isn't a specific line that can be pointed to in that agreement that says, for example, as you said, the decision to sell the property will be governed specifically by the majority vote provision. But on the first page, about 2 paragraphs down, there is language that all decisions shall be governed by this 51% majority provision. And there's the other ancillary provisions of, for example, the parties would be, the 51% majority provision would govern hiring real estate brokers. So I think it can certainly be inferred that that was the intent of the parties, that why else would one hire a real estate broker if it were not to sell the property? And in the brief, I quoted the Taylor case, an Arizona Supreme Court case, which clearly holds that the trial court should have admitted extrinsic evidence to ascertain the intent of the parties.
What you're really talking about, though, it sounds like, is asking the court to take that evidence to add terms that are not there.
Well, Your Honor, under the Taylor case, the Arizona Supreme Court case, it clearly states that Arizona has rejected the restricted view of contract interpretation and instead has adopted the Corbin view. And so the analysis that the trial court employed of first determining whether the contracts were ambiguous and this whole concept of adding terms is simply not the law in Arizona, respectfully, but instead, it is the trial court's duty to ascertain the intent of the parties, and therefore the court should have admitted extrinsic evidence.
But even under the Corbin view, the court can't take extrinsic evidence to add terms. Get it?
I don't think that it would have been necessary to add terms. I think that the parties, many of whom are real estate attorneys, real estate brokers, mortgage brokers, appraisers, one gentleman sat on the appraisal board of appeals, could have testified that that was their intent. That taken together, looking at all the provisions in that contract and without adding a single word, that that was the intent of the parties. And I think one piece of evidence that you can see is the caption of this matter showing that every single party in this case, other than Mr. SPENO, his wife, and their related entities, all agreed that that was the intent of the parties.
Okay, go ahead.
Thank you, sir. Defendants breached the contracts by failing to pay their proportionate share of real estate taxes and other expenses to preserve the properties, including the fees of attorneys who were hired to prosecute foreclosures and to represent the parties in connection with bankruptcy filings by some of the borrowers. In the trial court's September 2013 opinion, the court ruled that Mr. SPENO had to pay his proportionate share of the taxes and expenses to preserve the properties, which he had not done. And so, in effect, the trial court ruled that he breached the contract. There's never been a ruling in this case in the trial court ever that my clients ever breached these contracts. However, the trial court also ruled in its September 2013 ruling that in large part the contracts were unenforceable as they did not pertain to many decisions involving the properties, such as when to sell the properties. The trial court used as the basis for its ruling that the contracts were too short because they were only 1.5 pages and therefore couldn't possibly cover the issues at hand. The court cited no appellate decisions that contract is insufficient merely because of its length, being 1.5 pages, or that it's too short. This case was first assigned to the former Judge Thomas LeClaire. Judge LeClaire, following the September 2013 ruling, ordered that these properties would be sold pursuant to the partition statute. However, Judge LeClaire did not follow the prerequisites of the partition statute, and we filed a special action in this court, upon which Judge Winthrop was one of our panelists. And the court took jurisdiction of the case and overturned the judge's decision and ruled that he had abused his discretion and exceeded his authority in his ruling to sell these properties pursuant to the partition statute. In connection with that order, Judge LeClaire appointed a real estate agent by the name of Lee Kopelman. Lee Kopelman was married to Sheila Kopelman, who was the judicial assistant in the courtroom next to Judge LeClaire's courtroom. The Kopelmans stood to gain over $200,000 in real estate commissions from the sale of these properties. Also at that time, the Kopelmans were being sued in the Maricopa County Superior Court for failing to pay their credit card debt. And subsequently, a judgment was entered against them in a case involving a debt buyer called Midland Funding Corporation. So of all the thousands of real estate agents and brokers in the state of Arizona or in Maricopa County, Judge LeClaire picked Lee Kopelman, who again was married to the JA in the courtroom next door. I talked to Mr. Kopelman by phone. He told me that he believed that he owed no fiduciary duties whatsoever to my clients, not the duty of honesty, not the duty of loyalty, not the duty of fair dealing, and he also had no listings which were in any way comparable to the properties at hand by virtue of their size. One property was a 60-acre parcel, and he had no listings in outlying areas. And the rules of the Arizona Department of Real Estate provide that a real estate agent or broker is prohibited from taking on a listing unless they have experience and similar listings, not just in the type of property, but in the locale. I filed a very respectful and well-drafted motion in front of Judge LeClaire asking him to please reconsider the appointment of Lee Kopelman. I was instructed to appear by telephone, as was my opposing counsel. When we got on the telephone, Lee Kopelman was already in the courtroom speaking with the judge when we got on the phone. Judge LeClaire went off the record. He told me that he was going to put me in jail if I persisted in filing motions like this. I had no choice but to file a complaint with the Judicial Tenure Commission, as did my co-counsel and several other parties, and Judge LeClaire resigned from the bench a short time later. And just for the time frame, it's very important here. So this telephonic hearing where he threatened to put me in jail happened on March 5th of 2016. On March 10th, 5 days later, we filed a motion before the chief judge for change of judge. 1 day later, so that was 6 days after threatening to put me in jail, and 1 day after we filed a motion for change of judge, Judge LeClaire issued his order awarding attorney fees against my clients. I think that timing is extremely significant. Again, on several occasions, my clients proffered evidence of intent of the parties. I did so in the September 2013 hearing. At the end of it, where I could see the judge was going to rule that the contracts were in large part unenforceable, we tried again in an April 1st, 2015 hearing, and again, the judge would not hear intent of the parties, which violates clearly the Taylor case, which again is described in detail on pages 27 and 28 of my brief. The attorney fees awards in this case are clearly based on errors of law of not following the Taylor case, and the other matters that I've already described to the court cast doubt on the appropriateness, with all due respect, of Judge LeClaire's decisions to award attorney fees in this case. I'll reserve my remaining time unless your honors have questions.
Good morning. May it please the court. I'm Glenn Hotchkiss, and I represent the appellees in this matter. I'd like to start my remarks by pointing out what is not at issue in this appeal. First of all, my opposing counsel spent a decent amount of her time talking about the supposed bias of Lee Kopelman, who was appointed to sell the properties, and former Judge LeClaire, who was the initial judge in this case. None of that is the subject of any of the issues on appeal that appellants listed in their opening brief.
And when did the stuff, all that occur?
I'm sorry, when did that occur? That was all in
about the person listing it for sale and the disputes?
Yes, that was in 2015, Your Honor.
Before the special action?
Before the special action, that's correct. And they did, in fact, raise that in the special action, and the court said we don't need to address that in the special action. My point is they've not included any of that in their issues on appeal. If you look at pages 22 and 23 of their opening brief, they list 5 issues on appeal, none of which mention the appointment of Mr. Kopelman or the supposed bias of Judge LeClaire. The other thing I would point out about this is that the presiding civil judge ruled on their motion for change of judge on the basis of all this supposed bias. That judge did so without requesting oral argument or an evidentiary hearing as they asked for, or even waiting for me to file a response brief. That's how little merit the civil presiding judge found in these allegations you've heard about today. They're discussed in the factual portion of appellant's opening brief, but you'll note there are no citations to the record for any of those statements, including the statements made here today to the extent that the Copeland stood to benefit by $200,000, presumably in the commissions that would have been earned selling these properties. There's no evidence in the record, whether it's in the trial court or whether it's before this court. There's no evidence to support any of that. So none of that is properly part of this appeal. What's also not part of this appeal is the judgment of partition that was entered by the second judge in the case, Judge Brnovich. Appellants have not appealed the judgment of partition and that ordered the sale of these 8 subject properties and appointed a different real estate commissioner to sell them. That judgment of partition is now final. And what that means is, regardless of how you decide this appeal, these properties are going to be sold. And in fact, 3 of the 8 of them already have been sold.
Well, I'm still curious about the effect of the special action in terms of law of the case, etc. It looks like Judge LeClaire had issued a ruling prior to the special action that said that the operating agreements do not address any rights, obligations, or procedures for maintaining property ownership after foreclosure. And that was challenged in the special action, but we didn't act on that. We said we reversed the partition because it wasn't properly pled and or tried as a partition action, correct?
Correct. The panel on the special action made a point of saying we are not reviewing the declaratory judgment ruling. We are only reviewing whether the trial court properly ordered the property sold. And it concluded the court did not properly order the property sold because it relied on the partition statutes without any evidence that would support an order of partition. What I actually asked the trial court to do.
Well, I mean, kind of implicit in that is that you could do partition if you did it right.
And that's exactly what happened on remand, Your Honor.
Implicit in that is that these agreements don't have anything to do with what you do after foreclosure.
No, actually, the agreements, as Judge LeClaire found, the agreements, under the agreements, the parties were tenants in common after the foreclosure. And in fact, opposing counsel admitted that in the declaratory judgment hearing. She specifically said that plaintiffs do not dispute that they are now tenants in common. That's in the declaratory judgment transcript, page 4, lines 11 through 12. That transcript starts on page 1658 of appellate's appendix. So she acknowledged they were tenants in common. The legal significance of that is each co-owner, therefore, owned an undivided percentage interest in the entirety of each property, okay? And what that meant is no owner could bind the other owners to do something the other owners didn't want to do with the property unless the beneficiary operating agreements specifically say otherwise. However, as Judge LeClaire found, and as counsel conceded when Judge Winthrop, you asked her the question just a few minutes ago, what specific language are you relying on to say that any and all decisions regarding these loans and these properties are governed by the majority rule? She couldn't point you to specific language. And that same colloquy occurred in the trial court with Judge LeClaire. Here's what Judge LeClaire said. He asks, so I'm asking you, besides what you've pointed out, where in the agreement does it say that the BOA has the authority to improve property, to enter into leases on property? Where does it say that? Ms. Goldman responds, well, I don't want to belabor the point, Your Honor. To me, it's implied in the provisions I cited, very similar to the answer she gave here today. In other words, there is no express language that says any and all decisions regarding these properties will be subject to the majority rule. The BOAs easily could have said that. And if they did, we wouldn't be here, because then it would be very clear that all decisions in the post-foreclosure scenario are governed by the majority rule. But instead, if you look at the language of the BOAs, you'll see that's not the case. They start out by saying 1% of the investment equals 1 vote. Then they say that an instructions sheet signed by a majority of 51% or more shall be binding on the group and may be relied on by anyone doing business with the group. Then in subparagraph C on page 1, it says, this authorization shall be used for. And it goes on to list a number of discrete, limited functions. Functions such as collecting money or other security due, hiring a trustee, sale agent, hiring agents to sell property or goods. And if you go on to page 2 of the BOAs, paragraph 2, it says, we may use any broker to lend, buy a loan, sell a loan, commence a trustee sale, or foreclose our security on a loan, sell property, and hire and fire agents based on our 51% vote.
Now, that list is inclusive by its terms, not exclusive.
Well, if you look at the lead-in, Your Honor, it says this authorization shall be used for. And our position is that limits this 51% majority provision to the specific listed items.
It does say including but not limited to.
Well, I'm not seeing including but not limited to. I don't.
I'm looking at a different version than you.
Yeah, I don't believe it does say that. But the point is.
Well, I mean, even if it does say that, we would still have to discuss what's the character of the kinds of things that are subjected to the majority vote provision.
I agree with that. And what is significant, and that's an excellent segue to where I want to go, which is there's nothing in this agreement that can be taken to mean that the majority has the right to insist that the parties long-term hold these properties over the minority's objection. There's nothing that says that they can do that. It does say the majority can vote to sell. And that's exactly what we've wanted the whole time. We've wanted to cut our losses and get out of these properties and sell, whether it's at a loss or not. The majority of co-owners, who are the plaintiffs below and the appellants here, have consistently said, we don't want to sell until the market comes back and we can get back 100% of our investment. And that is why these properties, with one exception, had been foreclosed on between 4 and 6 years before this action was even commenced. This action is now 5 years old. So what that means is these properties have been co-owned by combinations of the plaintiffs and the defendants for between 9 and 11 years. There is absolutely nothing in these beneficiary operating agreements that comes anywhere close to authorizing the majority to oppress the minority and force them to hold the properties for that length of time. As the court said, the BOA is mostly silent in the post-foreclosure scenario. And he said mostly because it does talk about foreclosures, does talk about hiring trustees, sale agents, and it does talk about selling the properties. What it doesn't talk about is what happens if the majority of owners want to hold the property and the minority, who remember are tenants in common and can't force each other to do anything, and the minority doesn't want to sell. How do you break that logjam? This agreement is completely silent on that. And that brings me to the extrinsic evidence issue. You're absolutely right, Judge Winthrop, in your question saying, aren't you asking us to fill in the gaps or add terms? Or perhaps the way you phrased it is, even under the Taylor standard, the court cannot fill in gaps or add terms. That's absolutely a correct statement of the law. With respect to this idea that the court did not follow Taylor, number one, it cited Taylor in its ruling, so it was obviously aware of the Taylor decision. Second, the court made a number of statements that are absolutely correct statements of the law. For example, the court said, the court said the court may not receive extrinsic evidence to add terms or conditions to the contract when the plain language of the contract gives it meaning and no interpretation is needed. That's consistent with what our Supreme Court said in Taylor. In Taylor, our Supreme Court said, even during the first step, meaning the first step of contract interpretation. The judge may properly decide not to consider the proffered evidence because it does not aid in interpretation, but instead varies or contradicts the written terms. And that's exactly the basis for Judge Leclerc's ruling here not to admit extrinsic evidence. It would have altered or varied the terms of the contract. They want to extend the majority rule provision to any and every decision the majority wants to make regarding the properties. But as I just pointed out, that's not what the agreement says. The agreement absolutely does not speak to how the parties are to hold ownership of these properties in a post-foreclosure scenario.
So it sounds like you agree that the operating agreement contemplates and specifically applies the majority rule to a decision to sell the properties.
It does say that, yes.
Wouldn't that imply a reciprocal right
No, I don't believe so.
to the properties?
I'm sorry. No, I don't believe so, Your Honor, because these parties hold these properties as tenants in common. That's been admitted, and that's something that Judge Leclerc found as well. The legal effect of that is no one party can force the other to do something over their objection, such as continue to hold the property. And if the parties wanted the BOAs to supersede the rights of tenants in common in that regard, they needed to do so expressly. In fact, the case, appellants argue that you can alter the statutory rights as tenants in common through a contract. I agree with that. Point is, they didn't do so here. And if you look at the Orphaley case that they cite, it's a good example. In that case, the issue was whether the musician plaintiffs should be paid after the last performance, as was prescribed by the Arizona wage statute, or instead be paid over a 12-month period as their contract stated. And what the court ruled was that the contract and not the statute controlled. And that's the result appellants want here. But if you go back and look at that case, the basis for the court's ruling was there was express language in the contracts where the musicians had agreed that they would be paid over 12 months and not per the statute. And that specific contract language is why the contract trumped the statute. There is no such specific contract language in the BOAs. There's absolutely nothing that says the majority can force the minority to continue to hold these properties for year after year after year, notwithstanding their status as tenants in common. They could have overridden the statute. They did not. Let me turn to the issue of the fee awards briefly. There were two awards made in this case. The first was made by Judge Leclerc in March of 2015, and it covered the attorney's fees and costs in the declaratory judgment proceedings and the orders for sale that preceded the petition for special action. And he awarded my clients roughly $27,000, which was about 50% of what we sought. Then, after remand and after the partition proceedings...
Appeals award fees?
I'm sorry?
Did we award fees?
I'm sorry. No, Your Honor, it did not award fees. Then, after remand, and after the partition proceedings were done with, and the judge entered an order of partition, as I've already said, at that point, the Judge Brnovich made a second award of attorney's fees in the amount of about $37,000. The starting point in reviewing an award of fees is that an award is left to the sound discretion of the trial court and will not be reversed absent an abuse of discretion. Also, it's important to note, appellants did not contest the amount of either fee award or any given time entry for which the fees were sought, either in the trial court or this court. So the amount of the awards are not in dispute and not part of this appeal. The only thing they challenge is the findings by both Judge Leclerc and Judge Brnovich that appellees were the prevailing parties. So let me turn to that. Judge Leclerc found in his ruling that appellees were the prevailing parties because, quote, the relief sought by defendants was awarded. And that relief came in two forms. The declaratory ruling itself, that found that the BOAs did not permit appellants to require appellees to hold the properties long-term over their objection, and the orders that the properties be sold. If this court affirms Judge Leclerc's declaratory judgment ruling, then obviously appellees remain the prevailing party in the first stage of the litigation. In the second fee award, Judge Brnovich found that after remand, appellees successfully obtained the judgment of partition, allowing them to sell the properties, the relief they'd been seeking from day one in this case. That's clearly a correct ruling that appellees, were the prevailing parties in the second stage. And because the appellants have not challenged the judgment of partition on appeal, appellees will remain the prevailing parties in the second stage of the case in the trial court, regardless of how you decide this case. In other words, contrary to what appellant's counsel said, the second fee award does not depend on the first. Your Honor, there's a handful of other rulings that appellants claim, there's a handful of other issues appellants claim that the trial court did not rule on. I see that I'm close to running out of time, and so I think I've addressed that issue adequately in my brief. In closing, I'd just like to say that I think Judge Leclerc got this right. I think he properly interpreted the beneficiary operating agreements as not speaking to the key issue, which is, can the majority force the minority to long-term hold the properties over their objection? I think that he properly excluded extrinsic evidence, because to admit it would be to alter or vary the contract, which is a violation of contract interpretation principles under either the plain meaning or restrictive view, or under the newer Corbin-Taylor v. State Farm view. So he correctly excluded extrinsic evidence. That's all I have, Your Honor, unless you have questions for me.
Thank you, Counsel.
Thank you.
Thank you, Your Honors. I'd like to first touch upon Judge Winthrop's discussion with Mr. Hotchkiss concerning, doesn't the contract apply to decisions to sell the properties? And he agrees that, yes, the contracts provide that the 51% majority vote provision does apply to decisions to sell the property. Inherent in a decision to sell a piece of property is when to sell the property and what timing will be best for the parties. The Taylor case. Mr. Hotchkiss mischaracterized the Taylor case and Judge Leclerc's rulings in connection with admitting extrinsic evidence. Taylor says that the court has to first consider what the proffer of evidence is. Judge Leclerc never did that. He failed to make any determination that the proffered evidence would vary or alter the terms of the contract. And that's really one of the main ways in which Judge Leclerc did not follow the Taylor case. And it is a reversible, clear error of law. Going on to the issue of the parties being tenants in common. Yes, but in the Offaly case, contract can trump a statute or rights at common law. And in the Offaly case, the court ruled that the parties had altered the effect of an Arizona statute by their contract. Similarly, in this case, the defendants signed these contracts and altered their rights under the laws of tenants in common by agreeing instead to a 51% majority vote provision as to when to sell these properties. They altered their rights voluntarily by contract. Judge Brnovich made it very clear that she was sitting not as an appellate judge but as a trial court judge, and she refused to revisit any decisions that Judge Leclerc made. We asked her to please look at this contract issue again. She said, nope, I'm not revisiting this. That's what the trial court did. Her decision to award attorney fees was based on Judge Leclerc's previous determination of prevailing party. And if you look at this case as a whole, Your Honors, we believe we should have won on the contract claim, obviously, and we're asking you to reverse that. But in addition, we also won on a very significant issue, which is the special action. Also,
Were you asking for an award of fees expended in the special action?
No. We are simply challenging, Your Honor, the awards that the trial court made in favor of the opposing parties for attorney
You're saying
fees
as a
against.
consequence of the special action, you partially prevailed.
If you look at the case as a whole, under the cases, determining prevailing party, and it's not just, of course, as you know, the contract claims it should be considered. It's did the client succeed on the merits overall? So we succeeded on the issues of partition, and that the Judge Leclerc order did not follow the partition statute. And ultimately, after the special action, because the market had changed, our clients agreed to partition. And so that issue was not further litigated in the trial court. We agreed to partition. So it's not that the appellees were successful on the partition claim at all. We stipulated and agreed to partition at that time. Really just a side issue. It's our understanding that the presiding judge in the trial court did not take action with respect to a change of judge because Judge Leclerc resigned from the bench. And in answer to Judge Thompson's question about the special action, although the issue of contracts were raised in the special action, it wasn't really the basis for a special action, and so we didn't ask for relief in connection with that, and the court did not award us relief and put that issue to the side.
It's a digression, but it's one of the problems with special actions. I mean, the propriety of the Judge Leclerc's ruling about the applicability of these operating agreements. The status of that after the special action is a little unclear.
I think it's completely unclear, Your Honor. I don't think in the special action the
In
court.
terms of it being conclusive while the case or res judicata or something.
No, sir. I think in the special action, the panel decided not to take up that issue at all, because it's not the type of issue that really is the subject of a special action, which is, a statute being misapplied and the parties needing immediate relief. For example, properties being sold rather, and we can't get those properties back. And so, no, the court did not take any action on the contracts claims. Do Your Honors have any questions for me? Just in summary, again, we believe we were the prevailing party. We ask that you overturn Judge Leclerc's rulings with respect to the.
I do have just one quick question.
Yes, sir.
You claim that there's some further amounts that are owed to you with regard to the foreclosure and bankruptcy filings, attorney's fees, and other things?
There are those issues, yes. Judge Leclerc said that Mr. SPENO and his group of defendants did not have to pay their proportionate share of all of the attorney fees that my clients had to pay for prosecuting foreclosures of the subject properties and defending the group in bankruptcy proceedings.
And what was the basis of his ruling?
There was no basis, sir. There was just an order that came out, and there was no ruling.
That's all I have. Thanks.
Thank you.
Council will take the matter under advisement, issue a decision in due course. Court stands in recess.